webinar series. Today's webinar series represents an ongoing collaboration between MU Extension, Labor and Workforce Development, and the Federal Mediation and Conciliation Service. Today is a great honor to welcome Roger McCrummen and BJ McCulloch from the McCrummen Immigration Law Group. I just want to let everyone know, as you probably know now, that this presentation will be recorded and shared on the Labor and Workforce Facebook page. However, I will stop the recording before the question and answer period. During the presentation, we ask you to please post your question in the chat feature, or you can simply save your questions till the end of the presentation. We can then have you unmute your microphones and you can ask our guest speakers directly. At this point, I would like to turn over to Roger and BJ and let them formally introduce themselves. Roger?
Yes, thanks, Matt. I'm Roger McCrummen, and I've been a lawyer now for 40 years. I've been practicing immigration law exclusively for the last 26 years. Our firm has 8 attorneys. All of us practice exclusively in the area of U.S. immigration law. I'd say that the bulk of us work in the business immigration law area. That includes BJ and me, as well as a few of the other attorneys. And we represent several local and national companies that often have a high volume of work visas. And but we also have attorneys that represent asylees, removal defense, and family-based immigration petitions. So sort of the full range of immigration work. I wanted to give you just a brief overview of the immigration area, and then we'll talk about some specific areas that we think may be more pertinent to more in line with your interests. Most attorneys, including me before I started doing this, know really nothing about immigration law, and the American public doesn't seem to too much either. But we have these broad categories of non-immigrants, people that are here on temporary with temporary permission, and immigrants. Immigrants are, we often refer to them as green card holders or permanent residents. In the non-immigrant world, there's an alphabet soup of different kinds of visas, and each kind of non-immigrant temporary visa has its own restrictions. And so, for example, people can be here on an F1 student visa, and there's certain restrictions to maintaining that status, or they can be here with a professional work visa like H-1B. There's certain requirements for maintaining that status. And so we're going to talk about some of the more common ones today, but then also take questions. Everybody that comes in the U.S. has a period of stay that's authorized by the by our laws, and if they stay past that period of stay, they would said to be out of status, and they could be removed from the U.S. I think of immigration to the U.S. as involving typically a relationship. So people often ask me, well, how can I immigrate to the U.S.? And people are surprised to know that a lot of people call us asking that question, and we say, there isn't any way right now, unless you have a family member who can sponsor you, or a job with an employer that'll sponsor you, or if you fall into one of the humanitarian categories, such as a fear of persecution, applying for asylum. There's also a limited number of people that come in every year on what we call the diversity lottery, where they actually have a lottery, and only certain countries are eligible for it, and Congress is constantly trying to get rid of that category, but hasn't succeeded yet. So anyway, but somebody who just wants to come to the U.S. to work, there's not very many options for them unless they're employer sponsored. I think I'll let BJ jump in and talk about employer sponsorship a little bit.
Sure. So we are obviously an immigration firm, so we believe wholeheartedly in the benefit of the immigrant community to employment, to communities as a whole. There are some significant benefits of employer sponsorship. Oftentimes, the immigrant workforce is highly trained in skilled positions that's not necessarily pursued at high rates by US students. And so they are helping fill gaps in our US-born talent, US-born training. So that's one thing. They help employers in that aspect. There's also evidence that the presence of foreign-born workers in the United States leads to an overall increase in wages for college-educated students at 7 to 8%, and 3 to 4% for non-college educated students in the U.S., non-college educated workers. So it's kind of a false narrative. Immigrants depress the wages through these employer-sponsored positions. In fact, they've actually been, evidence to increase wages overall. Microsoft uses a high volume of foreign skill sets, and they've said for every H-1B they hire, they're adding an additional 4 employees to help support the work that is created by that H-1B employee, whether it's through advancement of technology, different product offerings, etc. The National Federation for American Policy has found that for smaller companies, that impact is even greater. For each H-1B position added, there's additional 7.5 workers added. So overall, the narrative that H-1B employees, that sponsored workers pull employment away from the US workforce isn't necessarily supported by the facts, and neither is the statement that US workers' wages are depressed by the presence of foreign nationals in the workforce. There are a few things to consider when hiring non-immigrants. Anyone who comes to work for an employer in the United States must have valid work authorization. So we're talking about individuals who have requested work authorization from the government and have received it either through employer sponsorship of you all, saying, yes, we agree to sponsor you on an H-1B, or perhaps they have work authorization pursuant to another type of status. There are a few things to consider under I-9 regulations for the type of paperwork that you have to fill out when someone comes to work. We'll talk really quickly about what you're allowed to ask. How long they're able to work is going to be dictated by their work authorization. Whether or not they extend their work authorization is dictated by the particular category. For example, students, recent graduates from universities do not have indefinite work authorization. And in order to be able to continue working for you on a long-term basis, it does require employer sponsorship. Conversely, applicants who have work authorization because of a pending family-based sponsorship, for example, they're married to a US citizen, they're able to renew that work authorization on their own and they don't need employer sponsorship. So when you're looking at hiring a foreign-born national, there are a couple of things to inquire. You are permitted to ask, are you legally authorized to work in the United States? You're also authorized to ask, will you now or do you in the future require employer sponsorship? You are not permitted to request that they show you specific documents, and you're also not permitted to ask what's your status. That will kind of land you in some hot water for anti-discrimination issues and I-9 compliance. I-9 compliance is the, I guess, relevant law to ensure that everyone has proper work authorization in the United States. It protects you, the employer. If you go through the I-9 requirements, the I-9 documentation, it protects you from accusations of hiring an undocumented workforce. It protects against citizenship and immigration status discrimination, national origin discrimination, and potential accusations of retaliation. You do want to make sure that when you go through the I-9 process, the government has a wealth of resources available at the I-9 Central website. It's a part of USCIS. They have a handbook for employers to reference. It's called the M274. And that gives you instructions on what documents are permitted, what documents are associated with I-9, completed work work papers, and also kind of shows you some pitfalls to avoid. A lot of times employees will ask, well, what do you need to see? For me to complete the I-9, what do you need to see? And you do not answer that question with, well, just give me your driver's license and social, that'll take care of it. That's actually considered document abuse under I-9 rules. So you want to be careful in how you fill out your I-9, and how you communicate with your employees during that process. But the government, I think if you just Google I-9 Central, that'll give you some great resources to navigate. That could be an entire webinar on its own. So we'll just kind of gloss over that and move on to the common types of non-immigrant visa classifications that individuals could potentially use to join your workforce.
Okay, I'm going to go over some of those. And as I mentioned earlier, there is this virtual alphabet soup of different kinds of visas, and this isn't nearly all of them, but these are the ones we most commonly see. And we're going to talk about some of these one by one, I think. B1 is for business visitors. So nobody can work in the U.S. unless they have authorization. And the B1 category does not permit you to work in the U.S., but there are certain business activities that you can do. So you have a visitor from maybe an affiliated company abroad. They can come in and do certain activities like negotiate contracts, consult with clients and business associates. They can attend meetings, go to board meetings. They shouldn't be on the U.S. payroll because then it's going to look like they're working in the U.S. They can observe business. They can do things like gather information that they will take with them abroad to do the work abroad. So there was a famous case where Chinese tailor came into New York and took measurements and then went back to Hong Kong and made suits. And they questioned whether that was work or not. And they said, well, no, the work was primarily done in Hong Kong, and they were just coming into the U.S. to gather information. So that was still proper as a visitor, as a non-working visitor. But this is, I would say with the B1 category, it isn't always a bright line, and you see abuse of this category, but it is the way most visitors come to the U.S. is with a B visitor visa. There are some countries that allow people to come into the U.S. as visitors without having to first get a visa. So we should probably define those terms. A visa is the document that you get at a U.S. consulate abroad that's stamped into your passport, and it gives you permission to enter the U.S. for a limited period of time. And some countries, we have said, because of the low fraud rates from those countries, that they don't have to get a visa if they're going to come in for up to 90 days or less. They can't extend their stay while they're here. They can't change their status to something else. So we call those visa waiver countries, and that's typically European countries. I think Japan's visa waiver now in Australia. And so you'll see some people sometimes come in just like that without a particular visa. So it makes it a lot easier because right now, with the pandemic, a lot of the consulates are closed. They're not issuing visas, or there's long waits to get visas. But somebody who on the visa waiver program, who's from one of those countries, can come in much more freely. Although we do restrictions too from a lot of countries. Most of the European countries right now, we have a travel restriction. They have to try to get a waiver to even enter the U.S. There are, and we can talk about that more later if you'd like. There's a lot of recent developments in this area that have changed the landscape. Students are here on F1 visas, and a lot of times they are able to get work authorization following their graduation in a degree program. We call that optional practical training, or OPT. They can get a year in that. If they're in a STEM program like science, technology, engineering, math, they can get an additional 2 years in a work authorized status as part of their student status. And there's certain restrictions on that, on how much time they can spend where they're not working, and the employers have certain restrictions where the employers have to have a training program for them, but but it's very common to see that. Sometimes students can also get work authorization during their school term that we call curricular practical training. It's related to a particular curriculum they're pursuing. The typical.
Can I ask a quick question?
Sure.
Is there a designated description of the STEM fields? I'm just
Yeah.
curious whether construction can get stuck in there anyway.
Yeah, I'd have to check that. There is a list of fields that qualify as STEM fields. And do you remember where we find that, BJ? Is it on the Department of State side? Or?
I believe it's the ICE website.
ICE website, yeah.
Mhm.
Yeah, because they control the what we call the SEVIS program, which is what the schools use to record the status of their students. So we could send that link later. But yeah, there
Yeah,
is a
that would be great. Thank you.
there is a list of the fields that qualify as STEM fields.
Great, thank you.
And
Sorry to interrupt.
oh, that's fine. So the typical route you'll see that we see is somebody may be here as a student, and then get this practical training, and during that year, the employer would like to keep them, and so then their option is to apply for a work visa that would allow them to stay here a longer period of time. And the most common of those is the H-1B, which is for professional positions. So it's positions that require a bachelor's degree in a specialty area. And I'm going to skip for now the J-1 exchange visitors, I think, but the normal path we see is they apply for the H-1Bs. That's, and I guess BJ's going to talk about that, so I shouldn't have
That's okay.
jumped in
Keep
that.
going.
And there's a lot of restrictions on getting the H-1B because we have a limited number that can apply every year. So I'll let BJ jump in here.
Okay. Well, I'm always happy to let you keep going, just FYI. But it does require, we are actually seeing this week some revisions to the H-1B program. It is required for a specialty occupation, and that's generally defined as any job that requires a minimum a bachelor's degree in a specific specialty. And that specific specialty must be directly related to the occupation. So someone who might have a bachelor's degree in architecture, that's a specific specialty, but if they're working as a chemical engineer, that's not related to the degree or to the job. So it must be directly related to the duties of the job. The H-1B is limited to 6-year total. And for most individuals, well, I guess I should say for individuals born in most countries across the globe, that's enough time for an employer to start a green card process, which Roger will talk about later, and allow them an opportunity to obtain permanent residency during that time period. However, for individuals who are born in China and India, there's historically a higher rate of migration to the United States in those skilled categories, and they'll need the H-1B to be extended further beyond that 6-year category. So in that instance, even though they're limited to 6 years, if you begin the green card process, you can extend it beyond that 6 years. And Roger can talk a little bit more about that, but generally speaking, the H-1B can remain in effect for as long as possible until the individual obtains permanent residency during the required timeline under the regulations. The H-1Bs are subject to a numerical limitation. That limitation is 85,000 visas available every year. 20,000 of those are reserved for individuals with a master's degree or higher from a U.S. institution. Every year we submit the names in April of individuals who would like to be considered for those 85,000 available. If the application is selected in April, the H-1B will become effective at the earliest October 1st of the following year. So for example, October 1st just happened, which means if you find someone who needs H-1B sponsorship, the earliest we could file for them is April 1st, 2021. The earliest that H-1B would become effective is October 1st, 2021. So we're a little bit ways out now, but if that individual is currently a student or has recently graduated from a degree program, they likely have work authorization from that degree program that will tide them over until you can file for their H-1B. There are prevailing wage obligations that require you to pay at least the prevailing wage or the actual wage of U.S. workers to make sure that employers are not paying lower wages to foreign workers. And the work conditions also must be the same as U.S. workers. We talked a little bit already about the definition. We also have to show that there's a clear employer-employee relationship. So example, staffing firms are not traditionally eligible to obtain H-1Bs because you're simply hiring someone to go work at another employer. However, if you are, for example, an IT company and you have a contract to perform IT services as a consultant to another party, that is permissible so long as you show that you are still supervising the individual, you have the ability to hire them, fire them, promote them, discipline them, you oversee their work, etc. The E3 is very similar to the H-1B in the sense that it's still required to be a specialty occupation, still requires a bachelor's degree as a minimum point of entry in a specific specialty. They are granted for all 3 years at a time. They have the same obligations of wage requirements as the H-1B, but the E3 is specific to Australian citizens. So there's a slightly different process as far as the paperwork goes, but the regulations require much of the same items for the E3 as they do for the H-1B. And then Roger, do you want to talk a little bit about the TN?
Okay. You might jump in on the chat, BJ. Someone was asking about which institutions were exempt from the cap, and I started to type some of those out there.
Sure, I actually can't because I'm sharing my screen. I can't see the chat. Would you?
Oh, you can't see the chat. Okay, we may have to then supplement that later. But I know institutions of higher education are exempt. Governmental research organizations and organizations that are affiliated with governmental research. Some nonprofits that are associated with institutions of higher education that are, I think, do they have to be doing research? Anyway, there are some limited exemptions there from the cap. And that's very important because we probably get 4 times as many or 3 times as many applications for H-1Bs every year as they're allowed to process. And I should mention also that this administration has made it a goal to restrict H-1Bs as much as possible. And we've seen the denial rate for H-1Bs go from like 6% to like 39%, I think I saw. And so they've been harder to get approved. And I personally, I don't think that's productive for our economy, but at any rate, it has been a goal of the administration. The TNs, they still use that designation, but it's what was under the NAFTA. So we had a North American Free Trade Agreement between U.S., Mexico, and Canada. That's now been renamed the USMCA, I think, but they still refer to the visas as TNs. And actually, the change in the agreement really didn't change any with respect to the visas. It changed some tariff type rules for trade between the countries. That's been a very useful visa for many reasons, but for one is it's not subject to the same kind of limitations that the H-1Bs have, and it doesn't require a petition to be filed first with the USCIS, so it avoids those delays. It's limited to Canadians and Mexicans. They're the only ones who can qualify for TNs, and there is a list of positions that qualify for TN classification. So with the H-1B, you can get an H-1B for any position that we can successfully argue requires a bachelor's degree in a specialty area. But with the TNs, there's a particular list of occupations, and if it's not on the list, we can't get a TN for it. Most of them are professional positions, meaning they typically require a degree, but there's some on there that don't necessarily require a degree. There's and some that you wouldn't necessarily qualify for H-1B, we get a lot of animal breeders for some food processing enterprises that raise pigs, and some of those are qualifying for TNs, if they're or animal scientists, and there's ones for let's see, management consultant or scientific technician, technologist. That's someone who would work in support of someone like an engineer, but has at least 2 years of experience and has practical knowledge about the discipline and can solve problems. So sometimes there's some options there that wouldn't necessarily qualify for H-1B, but they could get a TN. We also have a category for trainees. It's not used very often, and it's restricted, and it's been difficult to get approvals in it. But this is for people coming into the U.S. They're work authorized, but they're here primarily for training. But there's a lot of emphasis put on classroom training versus hands-on training, and a lot of times the calls we get are they want somebody to be doing hands-on training, working next to somebody who's going to be training them. But this is really looking more at the hours spent in kind of a classroom type training, but they're able to do some while they're doing it too. That has a maximum of 18 months on that. Any work should be incidental to the primary purpose of the training. Another common visa is the L1 intercompany transferees. So suppose you have an affiliate abroad, affiliate company, and has specialized knowledge or executives that they want to move to the U.S. They can qualify under the L1 intercompany transferee. There's two categories that can qualify. There's ones that they're specialized knowledge employees, and those are ones that possess a knowledge that's not commonly found in the industry or in the company, that's needed in the U.S. They can be transferred to the U.S. Or executives or managers can be. They say when it comes to managers that it shouldn't be first line managers, and they're looking for managers who are managing other professionals, is what's more typical. They can get up to 7 years if they're executive or manager, and 5 years if they're specialized knowledge employees. This is another visa category that's been increasingly more difficult to get. They've been pretty restrictive on it. And right now, I should mention that there is a prohibition on the consulates even issuing H's and L visas for people to come in. Some of these proclamations, were a result of the pandemic, but it's also taking advantage to restrict some of these visa categories. Honestly, I don't know why we'd be restricting L1 intercompany transferees. I don't see them as having any effect on the U.S. job market, but that's ostensibly the rationale behind it. For larger companies, they can qualify for what's called blanket Ls, where we qualify all the affiliates first, and then they can go directly to the consulate and apply for the visa rather than waiting for approval of a petition by the USCIS in the U.S. So L1s are only valid for employees that are working at least a year out of the past 3 years for a company abroad that's affiliated to a U.S. company. So like a parent or subsidiary company, or a company that's under a common control with the U.S. company. Those are the kind of transferees we can bring in. And then we're going to talk some about, we thought the H2 category might be of interest to your group. So BJ is going to talk some about that.
Good, I saw a thumbs up. I don't usually see that excitement for H2s. So the H2s are temporary, I'm losing the word, temporary seasonal work. You've got to show that it's not a year-round position. They can be used for agricultural purposes, which are H2A, and then non-agricultural professionals, which is H2B. So if you think about it in the context of crops, growing and picking the crops can be considered H2A. But as soon as you bring those crops indoors and you start washing them, placing them in containers, sorting them, et cetera, that moves into the H2B. So for example, in the animal context, raising the animals, caring for the animals would be H2A, harvesting the animals would be H2B. H2Bs also pertains to landscapers, hospitality workers, roofers, et cetera. You have to show the government that it's based on a temporary one-time need, or temporary need that is seasonal in nature, peak load in nature, or one-time. So the one-time example, you can request up to 3 years if the need is one time. But if it's a one-time need, that means the government expects for you to never ask for it again. So an example of that would be building the Olympic Village, something where you're just going to do it once. Once the work is done, you move on and it never happens again. You can get up to 3 years for that. However, peak load need, seasonal need, temporary need, you're normally maxed out at 10 months at a time. You must the government that this need is based on recurring seasonal patterns. Seasonal would be based on, you know, your traditional outdoor changes of the weathers. Landscapers are going to be more heavily needed during the summer months, during the spring, summer, and fall. Obviously, lifeguards at a summer amusement park are going to be more needed during the summertime, and then ski lift operators, ski instructors more necessary during the wintertime. A peak load need, for example, if you have a manufacturing facility that manufactures children's toys, there's going to be a peak load ramping up to the Christmas months, and then after Christmas it kind of ramps back down. So these are going to be items where you say, look, I've got peak load is I've got a year-round need, and I have certain times of the year where I need more labor. Seasonal is going to say, I don't have a year-round need. I only have certain months out of the years where I need workers. And you show the government these needs based on pay records, client contracts from previous years, hours worked. So if you've had a study, if it's a peak load request and you have year-round business year after year, but you can show for the last 4 years, you've had substantial overtime requests from April through October, for example. You show the government that you're continuously straining your workforce year after year, and you now need to rely on additional help. It's a very onerous process. It's a 3-step process in most instances. First step is to test the labor market through the Department of Labor, advertise the position for every willing, qualified, and available U.S. worker. And these can be non-professional positions, so they don't have to require any experience. So any worker who comes and applies, for every U.S. worker that applies for the job, they reduce the number of foreign workers that you're able to bring. So for example, if you request 100 workers, you say, look, our data supports the need for 100 additional workers between April and October. DOL is going to say, okay, prove it. Show us that there aren't 100 additional workers in the U.S. workforce. So you advertise the position. Let's say 5 workers come and apply for the position. And you know these workers, they've applied for you every year. They come work for 2 days and then they leave. And so you know that this isn't going to be a long-term hire. The Department of Labor will still come back and say, well, they may not be a long-term hire, but you have a temporary need and you rejected them. So they'll reduce your foreign workers that you're able to hire by 2, or by 5. However many it is U.S. workers that you reject, they'll reduce your foreign workers by that amount. So it's a pretty onerous process where you're required to run recruitment. The Department of Labor oversees your recruitments. They're very strict in how you advertise and for how long you advertise. It requires a prevailing wage for the position that's also determined by the Department of Labor. And there's a very strict timeline. For the H2A, the earliest you can request, you can get the ball rolling on the process is 75 days before the date of requested need. For H2Bs, it's 90 days. So it's a very truncated timeline in which you have to get everything going. And then also it's a burdensome process with extensive obligations placed on employers, including the requirement to pay for transportation from the place of recruitment. So if you find workers in Matamoros, Mexico, you've got to pay for them to get their visa and their visa stamp, and then you've also got to pay for them to get to the United States. You also have to pay for the return transportation home. Those are just some of the attestations. They also have to be treated the same as U.S. workers. U.S. workers cannot be treated any better than nor any worse than the foreign workers. So H-2As and H-2Bs are a very involved process, but they do provide a great opportunity. If you've got this need where you can say, hey, look, I don't need to operate year round, but I do have a very short period of time where I've got a substantial need. Or if you say, I do operate year round, but there's periods of the year where we simply cannot keep up with business demand because of X. So these do provide great relief for those situations. But again, it's not something I recommend if you're only looking to bring 2 or 3 people. It's just such an onerous process, it's expensive, and there's a lot of obligations that go with it. So I typically recommend it if you're looking to bring a higher volume of people, simply to make it worth your time and effort. But that's not to say you can't only bring 1 or 2. It just, there's a cost associated with it.
BJ, somebody asked on the chat, how do you characterize roofers as seasonal when they could work year round? And so you might talk about peak load, the distinction there.
Yeah, so you're exactly right. Roofers can work year round, but there might be periods of the year where there's a higher demand. So it might be, again, you'll know it based on your business, but for any sort of, occupation that's dictated by weather. So I'm not in the construction industry, but I presume that construction industry ramps up a little bit more when the thaw has occurred, and when the ground is a little bit more able to be broken, where you can sit outside longer. So there's going to be kind of an ebb and flow to the contracts of the construction industry, where you're ramping up builds. And so even though you might have a staff that's on board year round for projects that continue through the winter, you can likely show an increase in projects, increase in contracts, in the labor necessary during the the warmer months, the more daylight available months, that sort of thing. And so that's how you show, okay, look, it's not truly seasonal in this instance because it's not dictated by the patterns of nature outside, but it really is more peak load. We've got a time during the year, and again, it can be up to 10 months out of the year, where you're saying, okay, look, really, we only have a couple of months where we don't need this high labor, but otherwise we've got a substantial need for higher labor. Does that help answer that question?
Yeah. Yeah, as an example, we have some meat processing clients, and that's a year-round activity. But there are seasons there where they have peak load demand. Christmas hams and stuff like that, where we can justify adding to the workforce with H-2Bs. Why don't I go ahead and jump to the green card part? BJ did mention does have a slide for O1 individuals. There is a category for individuals of extraordinary ability, or aliens of extraordinary ability, that and we've done several of these for business leaders, but it's a pretty rare category, and it shows it requires a lot of documentation of accomplishment and recognition in their field. But sometimes this comes in handy. There's not a cap on it, so in terms of a limitation of the number. But let's talk about the green card a little bit, and then we'll open it up for more questions. Green card process are permanent residents. So everything we've been talking about up till now has a limit on how long they can stay here. with work authorization. But once somebody has a green card, they can be here permanently. They're permanent residents. But it's an onerous process to go through, and it can take many years. And there are also limitations on how many from any one country can come in each year. But it requires a certification from the Department of Labor. We call this PERM, or labor certification, which requires the employer to go through a mock recruiting process where they list for 30 days the job in different locations. They interview people that apply for the job and see if they meet the minimum qualifications for the job. If we successfully get through that, then the Department of Labor can certify it. Basically it's a process of showing that there's a shortage and you can't find the necessary people you want with a particular skill set. And it takes about a year to go through this process, because you have to get a wage determination from the Department of Labor. Those are taking 5 or 6 months right now to get. And then the second step in the process is a petition with the USCIS to classify somebody as an immigrant worker. During all of this time, they have to maintain their non-immigrant status. And this can be approved fairly quickly. But the key thing is the last stage, adjustment of status. That's where they actually apply for the green card. Well, there is a limit on how many people every year can apply for employment-based green cards. And there's also a limit on how many can come from any one country. So if you were to ask yourself, where do we see the most immigrants in the professional ranks right now? Well, that's from India. And then China is probably second. Well, as a result, Indians may be waiting 10 to 15 years after going through the first 2 stages before they can get to the final stage. And we have a mini crisis in our firm this month, because suddenly the Department of State every month issues a visa bulletin saying which priority dates can be processed. When they starts this process, they basically get a number we call a priority date, and they're standing in this line. As of October 1, the line jumped forward 5 years in the ability to file for adjustment of status. And that's going to cause, I think, probably tens of thousands of people to suddenly file all in the month of October. But if they don't file in this month, the numbers may change next month. They may retrogress. And so people that are eligible to file this month may not be able to file next month. So when I said that's creating a mini crisis in our firm, suddenly we have over 100 of these that we have to file, and each one of these applications is probably 4 to 5 inches thick of paperwork, and it's very important that people get in the process, when they have the chance to, and it kind of preserves their right to stay here while they're waiting for the green card to finally be issued, and it may take another couple of years after they file. It may take 5 years, because the numbers often what we call retrogress. You're eligible now to file, but they still may not process the case for another 5 years. So it requires a lot of patience for somebody to get a green card in the U.S. Now, people from other countries that aren't India, they may go through it faster. It may take, but it's still going to take probably 2 or 3 years for them. So a lot of times a green card isn't a good option for a worker you're trying to bring in, unless they have another non-immigrant category that they can work under, like H-1B, because otherwise they're waiting outside the U.S. for 2 or 3 years while you go through this process, and that's not a practical business solution for most businesses to wait that long. So needless to say, there have been a lot of changes under the Trump administration. There has been a concentrated effort to reduce levels of immigration, and statistically they've definitely succeeded in doing that, all the way from cutting refugee admissions from 110,000 maximum under the Obama administration to just 10,000 next year. Dramatic cuts. And you may think, well, what do refugees add to the U.S.? But a lot of these places like meat processing plants, they relied really heavily on refugees coming in with very little skills, coming in and working in their plants, and they give them good wages and places to live and stuff like that. They're actually hurting because we're not admitting as many refugees as we used to. And then all the way up to professional visas like H-1Bs, the there's been a reduction there. And just taking effect tomorrow is a new regulation, unless it's enjoined by the courts. There's a new regulation that changes dramatically the way we calculate the prevailing wage for H-1Bs. And so we've just seen change after change. A lot of them have been enjoined by the courts because they haven't gone through the proper procedures for the Administrative Procedures Act, and so it's been a constant battle. I mean, immigration has been a really hot spot during the Trump administration, and it would take forever to kind of list all those changes. But I used to try to keep a catalog of them, and I just kind of gave up after I reached about 100. And so anyway, why don't we stop here and open it up for questions?